Hello, my name is Daniel Smith, and I'm an attorney with Advocates in Aging, Law Office of Wiesner Smith in Sarasota, Florida. Today, I'm going to be talking about probate. What is probate? Probate is the legal process of administering a person's assets after death. A question I'm often asked is probate required? The answer is it depends. We need to look at the specific asset or assets that need to be administered. For example, assets that are in a joint account owned with a joint account owner pass to that joint owner at the time of death and do not need to be administered in the probate court. In addition, accounts with a designated beneficiary, such as an IRA, do not need to be administered as those assets pass to the designated beneficiary by operation of law at the time of death. Also, bank accounts that are TOD or POD, which is transfer on death or payable on death, do not need to be administered as they are transferred at the time of death outside of probate to the proper beneficiary. Assets that are held in trust are administered by a trustee outside of probate and do not need to be administered through the probate court. Now, there are some special circumstances where probate may be required. One example is the homestead property. You may need to get an order determining homestead status on the homestead property from the probate court, even though it is technically a non-probate asset. In addition, if a surviving spouse is disinherited by a will, the spouse does have a right to claim an elective share of the estate and will need to claim that through the probate court. In addition, if there are known creditors, you need to open probate to start the clock, so to speak, to run the 90-day creditor period for the creditors to file claims against the estate. Alternatively, you can wait 2 years from the date of death because at that point, all creditor claims are barred. Next, I want to discuss some probate terminology. First, an estate means a probate estate or property subject to administration. Next, the decedent is the person who died. The personal representative, as it's known in Florida, is the person in charge of administering the estate, known as the executor in other states. Next, intestate means a person who died without a will. Testate means a person who died with a will. Next, I want to talk about the three types of probate. The first is disposition without administration. This is for small estates of $6,000 or less, where the preferred funeral expenses plus medical expenses of the last 60 days of the decedent's life do not total more than $6,000. There's an easy procedure for this. You just fill out the appropriate form, send the required documents to the judge, and the judge enters an order. It's a quick process for small estates. The next type of probate is called summary administration. Now, summary administration is for probate assets that consist of $75,000 or less, or where the decedent has been dead more than 2 years. The process for summary administration consists of filing a petition for summary administration, and if a will exists, the judge will enter an order admitting the will before entering an order of summary administration. It is important to consult with your legal counsel before sending that proposed order to the judge because certain banks and financial institutions have strict requirements for the language required on that order to be able for the beneficiaries to access those funds. The third type of probate is called formal administration. Formal administration is required when the assets that need to be probated consist of those of $75,000 or more. Now, formal administration, the process starts by the filing of a petition for administration. You also file the death certificate with the court, and the personal representative will file an oath with the court. If a will exists, the will be filed with the court. If you cannot locate the original version of the will, a copy of the will can still be probated through the process known as a commission to prove the will. For the commission to prove the will, the court will appoint a commissioner to take the oath of one of the witnesses to the will to prove that will to have it admitted to probate. The judge will then enter an order admitting the will and an order appointing the personal representative who will then administer the estate. The judge may require a bond to be posted by the personal representative, but your probate attorney can assist you with obtaining that bond. The bond requirement is typical where the personal representative resides out of state. The judge will then issue what are called letters of administration. This gives the personal representative the legal authority to administer the estate. You will take a copy of the letters of administration, a certified copy, to the bank along with the estate's tax ID number to open an estate bank account where the decedent's funds can be transferred. This will allow the personal representative to have a separate account to administer the estate from. Now, the letters of administration will give the personal representative the authority to sell assets, including real property, depending on the will provisions, and also bring legal actions on behalf of the estate. Now, there are notice requirements involved in probate. First, a notice of administration is required to be served on the surviving spouse, any beneficiaries of the estate, and any trustee of a trust holding the decedent's assets. However, you can get a waiver signed by any of these parties to avoid that requirement. Next, you will need to publish a notice to creditors in the local newspaper to start the 90-day creditor period in order to allow creditors to file claims against the estate. Your probate attorney can assist you in objecting to any claims that are improperly filed or invalid. Next, the personal representative is required to file an inventory with the court within 60 days of issuance of the letters of administration. This period can be extended by the court if additional time is needed. The inventory will include a list of all the assets of the estate along with an approximate value. The inventory is required to be served on the surviving spouse, any heirs in an intestate estate where there's no will, or any residuary beneficiaries in an estate where there is a will, known as a testate estate. Next, I want to talk about homestead. It's important to file a petition to determine homestead status where a decedent's homestead needs to be administered. This is because the Florida Constitution provides great creditor protection against the homestead. The judge will then enter the order determining homestead status, which will then entitle the beneficiaries to the homestead free of creditor claims. Next, I want to talk about other exempt assets. The surviving spouse, or the children if there is no surviving spouse, are entitled to furniture, household furnishings, or appliances up to a $20,000 value. In addition, the surviving spouse, or children if there are no surviving spouse, are entitled to 2 vehicles. Next, the personal representative will distribute the estate. First, administrative expenses such as attorney fees, funeral cost, or personal representative fees will be paid from the estate funds. Next, any valid creditor claims will be satisfied. Finally, the personal representative will distribute the remaining assets pursuant to the terms of the will to the proper beneficiaries, or if there is no will, pursuant to the intestacy laws in the state of Florida. Finally, the personal representative will file the closing pleadings, including a petition for discharge. The judge will then enter an order of discharge, which relieves the personal representative of his or her duties. That concludes my discussion of probate. Again, I am Daniel Hooper Smith, attorney at Advocates in Aging, Law Office of Wiesner Smith in Sarasota, Florida. You can reach me by phone at 941-365-9900 or on our website www.wiesnerlaw.com, and that's WIESNERLAW.com. Thank you.